We are the last panel that stands between you and the rest of your Saturday afternoon. So we will get started on time. And I want to lead, as the other panels have, with tremendous thanks to Michael, to Jed, to Morgan, for a great conference. We are going to emulate the same high level of discussion that has preceded us. I have confidence in this crew that they can do that. We are going to do one thing differently, which is we are going to begin with brief comments from myself and Katerina, and then go down the line and have our panelists speak. And that's in part because we are sort of engaged in a debate that has been going on for a while, and our comments are probably going to be more about some of the papers that were in the past of this debate, and they will then be carrying it on. So you'll see it in live motion. So as many of you know, the instigating force behind this debate over delegation or non-delegation was Gorsuch's call in 2019 in Gundy for overturning the established and lenient non-delegation doctrine in favor of a general prohibition on Congress delegating authority to set binding rules governing private conduct and to delegate that to agencies. Gorsuch justified his approach in part, which will relate to one of my comments, on original understandings. And it also appeared like there were now 5 or 6 justices who would be sympathetic to this view. So this sparked a renewed, there had already been perennial discussion of delegation and non-delegation, but this sparked a really renewed and intensive scholarly investigation of the founders' views on non-delegation. And I think it's fair to say that the debate has been quite contentious, to put it mildly. Julian, Ilan, and Nick have contributed leading works in this debate. And I thought I might just begin, since Katerina and I are going to be commenting on those, by giving a very, very quick, with apologies that I am missing all of your guys' great nuance, summary of those papers. Let me begin with Julian. So Julian, writing with Nick Bagley, his colleague at Michigan, concludes that there was no discernible legalized prohibition on delegation of legislative power, at least so long as the exercise of that power remains subject to congressional oversight. And in reaching that conclusion, they based it in part on an in-depth survey of early Congresses, which they conclude contains only very rare hand-waving by a few at times at non-delegation, even in otherwise heated constitutional debates and policy debates. They also identify many laws that granted executive actors authority to adopt exactly the type of kind of binding rules that Gorsuch deems constitutionally prohibited. So you've got Julian and Nick on the one hand saying that there is no such discernible legalized prohibition on delegation. That's evident in the founding record. Ilan rejects that view. He also surveys the record of early congressional debates and actions and concludes that there is significant evidentiary support for the claim that the founders adhered to non-delegation doctrine, and distinguishing the counterexamples that Julian and Nick supply, as well as some that our own Nick supplies. And Ilan ends up arguing for a version of non-delegation doctrine under which Congress must decide all important subjects, leaving matters of administrative detail to the executive, which he also maintains would not call much of the administrative state into question. Nick Perillo, finally, takes a slightly different tack. He looks in detail at one particular measure, the direct tax of 1798, focusing in particular on the rulemaking power that was given to boards of federal tax commissioners in each state to raise or lower all assessments within any district as shall appear to be just and equitable. And Nick argues that this represents an early congressional delegation of coercive rulemaking authority and wide discretion in a domestic context. And in his piece, he assumes he's willing to grant arguendo. There may be some constitutional limit on delegation, but he concludes that the 1798 direct tax is important evidence against Gorsuch's account, an effort to root a prohibition on Congress's ability to delegate authority to impose binding rules on private conduct in the founding generation's views. Okay, as I told you, very quick and dirty. Correct the record as you like when we get down to you. So I have 4 comments or questions, but I may hold the fourth and just do the first three to get us going. And my first three comments are interrelated, and they go to questions about what does the historical record show, which is at the center of this debate, what we should expect it to show, who bears the evidentiary burden, and what work originalism is doing here. So I was very appreciative of having this role in this panel because although I have followed this debate, I had not done the deep dive into everything that had been written on it. And it has been a lot, thank you. But after that deep dive, I come away thinking it is hard to conclude that the founders had a definitive collective view on delegation. I think that the evidence that Julian, Nick, and others provide weighs strongly against concluding that there was collective ascription to a prohibition on delegation of the kind that Gorsuch advanced. At the same time, Ilan and others do offer some evidence of non-delegation concerns in the ether. The cupboard is not entirely bare there. And there are signals of some abstract limit that seem to grow a bit over time, particularly through the 1790s, although the contours of any such limits, I think, remain quite indeterminate. It also isn't at all surprising to me that the founders wouldn't have a definitive view. They were building a new government. They were figuring out interbranch relationships and what kinds of relationships and arrangements might make sense. Kevin Arlick has a piece in this debate where he says basically they were figuring out what governance relationships worked. I think that is what you really see as being in play here. Now, I want to emphasize that saying there wasn't a definitive collective view at the time of the founding doesn't mean that such a definitive and collective view doesn't emerge over time, right? Which it could. And so the question that I would put to the panelists, I think Ilan's going to disagree probably with the presupposition there wasn't a collective definitive view, but I guess the question I would have for Nick and Julian is, what if we look beyond the founding era? Is there more evidence that you've seen that such a view emerges at all? Certainly there have been claims that it does. And are you as skeptical of those claims as others? This leads to my second and related point, which is who bears the burden of proof? And it is fascinating that this question of who bears the burden of proof lies at the center of this debate. Participants take very diametrically opposed views. So Julian argues that the burden lies on those who are claiming there was a prohibition on delegation to show that it exists. So silence defeats the claim. I think in his more recent piece that comes out more clearly. Ilan, you take the opposite view. You switch the burden. You fault Julian for not coming up with evidence that necessarily refutes the proposition that Congress cannot delegate decisions involving private rights. I am not a historian, so maybe this is par for the course. It strikes me as unusual that a historical debate would turn so much on who bears the burden of proof. So I'm curious if that's true. This is the norm. On one level, though, it doesn't seem surprising to me that there is this debate because I don't think that what we're seeing in this context is really just a historical debate or even, honestly, primarily a historical debate. I think it's a contemporary debate. It's a contemporary debate about the shape of national government and whether or not courts should start paring back regulatory delegations and regulatory power. And when you view what's going on as really a doctrinal fight, I think that also suggests another lens to think about who should bear the burden of proof, and it's stare decisis. And it's what is our current doctrine and who wants to change it, and those who want to change it would need to bear some of the burden. That's where I would put the burden of proof. And that would, again, be in favor of the current lenient approach to non-delegation. My third point, and after this I'll hand off to Katerina, is that I find there's a striking disconnect in this debate between the detailed historical work that is being done on delegation and the very casual historical invocations by Justice Gorsuch that seemed to provoke it. And to be frank, I don't read Gorsuch's opinion as animated by a historical vision. I read it as instead driven primarily by a particularly ideologically infused view of constitutional structure. I think that vision that he has is deeply suspicious of administrative regulation. It puts a primacy on negative and individualistic conceptions of liberty. It draws on a formalist understanding of constitutional structure, and it views the Constitution as fundamentally aimed at curbing governmental power, right? This account, of course, draws on historical evidence of the founders' concerns with constraining government, as has come up at various times over this context. I don't mean to suggest that it is ahistorical, just that history is not the driver. So, for example, if you read Gundy, you'll see lots at the beginning about Congress as a representative institution, and it operates subject to the constraints of bicameralism and presentment. All of this was structures that were supposed to make making law difficult. The problem with delegation is that it makes making law too easy. That, to me, is, again, this kind of structural ideological view, as opposed to primarily driven by history. So one other point I'd make about this is that I think that although there is certainly historical support for the idea of a concern on the part of the founders about governmental power and about constraining governmental power, that is only a partial story of the founding. There was also a great deal of concern about empowering government, empowering national government, part of the Constitution was about granting Congress important new grants of power, tax, interstate commerce, creating a direct relationship between citizens, as well as, of course, the creation of the separate executive for energy and government and so forth. And so I think the account of constitutional structure that Gorsuch offers is very much one-sided. My sense, though, that that's what's really driving it does make me ask what exactly those of you who are in this debate think, what is the work that you think historical scholarship is doing here? Because it seems to me, if you accept that what's happening is a sort of ideologically driven effort on one side, and it's really contemporary debate, in essence, about government, it seems very unlikely that there will be persuasion across different views on this issue. And so I'm just curious about what you think is going on. To me, somewhat, I think it's a fight over whether or not there'll be a certain kind of intellectual cover for for the debate. But that is probably maybe it's an unduly cynical view. I also just want to underline, as potentially one of the few, I'm not sure, non-originalists in the room, that I really don't think you can resolve this debate by simply looking at the originalist views of what the founders believe. That is one part of evidence you would look at. But it is now 230 years later. We have had 230 years plus of implementing the Constitution. We have a national government that has arisen, premised in part on Congress's ability to delegate authority to issue binding rules that govern private conduct. That is our legal and practical reality. And I think any effort to pull back on that has to be justified in straightforwardly normative terms. It has to be, the normative terms can be about why originalism is the right prism, but you can't avoid that step. I think it's very hard to justify in normative terms because I think that this effort is profoundly undemocratic and disruptive of the court trying to transform the government and society for us rather than leaving that to democratic forces. I also think that there are very important pragmatic concerns about what a revised, what this invigorated non-delegation doctrine would mean for the courts and for the ability of the courts to develop implemental lines, which is another problem to adopting it that focusing just on originalism doesn't capture. Katerina?
Thank you so much for that, Jillian. Thank you, Jed and Michael, for inviting me, and Morgan for organizing, and everyone for sticking through the very last panel of a provocative conference. My work is in international law and in methods, and I was asked, is there something similar to the non-delegation doctrine and what the Europeans are doing? At the EU level, the answer is absolutely not. The effort to constrain the Brussels bureaucracy in these terms is not there. And even in terms that would be much more straightforwardly based on the treaty, the court is very eager to go along with the Commission and the Council to promote more federalism. So that's not going to be a fruitful route. Matthias Kuhn wrote about the one case where some act was struck down by the court as an excess of power, but it's very rare. Instead, what I will talk about is methodology. So my training is in social science, and I've gotten this great arbitrage opportunity. I translate debates that social scientists spend decades fighting into law review articles, and I rewrite the same piece, like 2 book chapters this summer, and More coming. And it's the same idea. So I'll just explain some words. They're not my words, but I think they're useful in terms of, what do you do when you look at thousands of pages of the record and you don't find a lot of evidence? You could use it in lawyerly terms and talk about burden of proof, but there's some other approaches that are also helpful. Nick and Julian and Ilan use a lot of social science terms, and I just wanted to build on some of what they do and say kind of just as we have canons and counter-canons, what the response would be. So one of the summaries of Nick and Julian's point is, look, originalists are overfitting the data. They have a thesis, and then every time some new piece of evidence comes up, they tweak it a little bit and find another exception and another caveat, and that's no way to do good thinking when you could just draw a straight line that comes out the other way. The social scientific response to that, Ilan, if you wanted to put it forth, is look, it's an iterative process. And if our theory has scope conditions, this is not a problem, it is a virtue. Most theories have conditions under which they work.
Can you send that all to me?
Of course. I rewrite this, yeah. Ilan, now on your account, you do you have this really great sentence and you say, look, my theory does have an evidentiary problem, and that's Nick. Like, yes, Nick's analysis of the direct tax of 1798 is a real problem, but one swallow does not a spring make. Now, this is a problem a lot of us have, and some of us say, like, yeah, I only have one counterexample and it's a problem, or I have one example and there are many more. Just read the record yourself. I'm not going to bring this to you. So if you have one example and you want to make a spring out of it, you call it a critical case. And there's a really good theory around critical cases, right? So,
Could you send me that?
Yes, yes. So the hollow hope, I think, is the best example in constitutional law. Like, if I want to show the Supreme Court doesn't change public opinion and I have two cases, well, Roe and Brown are kind of good options. In international law, we say, like, if even Hitler hesitated in using this particular technology, like chemical weapons on European populations, like maybe there's international custom, there's a rule prohibiting it. And I think here, kind of characterizing this as, look, this is the most difficult case, right? It's a situation where it is domestic, it's private, it's 1798, it's not some other year, it's taxation, it's enumerated, like all of this would bring up the critical case language and idea. That said, let me bring some complements of this debate that were surprising to me, and then kind of some ideas on how this could go forward. So to me, there is some agreement, and Ilan underscores this, that the record is voluminous, that there is, like, it is possible as an evidentiary matter to figure out what people thought because they left all these writings, right and left. This makes originalist scholarship possible in ways that other types of historical work is not possible. There is really clear debate about decades, so we really care about the founders. We care about what happened in Britain, but we interpret it a little differently. And we care about what happened later. And this is, I think, what Jillian speaks to, right? So if concerns about non-delegation arose later, that too is a good moment of consensus. Generally, as a social scientist, I tend to like papers that are written the way Nick writes them, like carefully, from a neutral perspective, not from a kind of like, I have a strong belief and here's the evidence. But having read your work, I think you're really speaking to each other. Like, I think, like, you're really doing a lot of work through this adversarial framework. You are narrowing the terms of the debate, and I thought that was surprising and really fruitful for me. Now, let me just make 3 recommendations for kind of going further. Let me start with the denominator. So the denominator that comes up in a lot of this writing is tens of thousands of pages. There should be evidence either in favor or against. And there's another denominator, Ilan, that you bring up, and you say, yes, there is one member of the House of Representatives, implying that 1 out of 100, or I don't know what the number is, what the right denominator is. But I don't think that's the right kind of denominator. I think the right denominator is to look at the 4 or 5 examples of statutes that could have given rise to non-delegation concerns. And just to be really, really explicit, I think Nick and Julian in their piece say, like, look, we have these many examples, and there might not be many. If you have 4 good ones, that's all you need. And just speaking about how many you have in precise terms, if they're just like the tax of 1798, really great examples, you don't need that many. And just saying, look, these are the contexts where we want to dig deep. We have 10 pages of debate on these particular, like that's going to really strengthen the piece. The other really interesting question is types of evidence. So there's a lot of focus on statements and less focus on actions, which was surprising to me, given other questions about, like, people make statements for all kinds of reasons. They make statements that are pretextual. They make statements that are self-aggrandizing. And this question of incentives to make statements only comes up in Julian and Nick's work, right? So you say, as far as I understand, look, if you want to kill legislation, you're going to throw every possible argument at it. The fact that it didn't occur to you to throw this argument about non-delegation means it must not have been a possibility. So I think, that's really good thinking. In the technical term for that would be process tracing. So the thinking, don't laugh, it's a really good idea. It's not mine. So the idea is, just like a detective has a theory, where theory is a set of interconnected logical propositions. Like, first, there's a motive for the crime, there's an opportunity for the crime, there's evidence of the crime. So I need to just spell out, like, what exactly is the counterfactual. If they had thought, and you have to, unfortunately, Lon, this one's for you, if they had this in their mind, they would have raised some objections when a statute giving rise to these concerns came up, and we would not see it in the rest of the record, but we would see it in these circumstances, and the reason they would have raised these objections, or the reason they would not have raised these objections, is because some other argument would have carried the day. But just spelling out the theory and its implications, and then testing not only for statements, but for actions, is one way to make progress on what is already a very rich debate. So let me end here and
Julian.
pass them.
Yep. I think we're going to head to Julian.
Sure. I am going to spend my initial time, although I look forward to digging in much more to the particular questions, which are wonderful and rich and very on point in lots of ways that challenge both Alon's work and ours. But I want to spend my initial time trying to clarify what I think has been the hardest element of the big picture structural framework to convey. The big picture structural framework for thinking about the separation of powers as distinct from mixed government, and the way the founders' vocabulary around executive power and legislative power worked. And it starts, the question is framed, and I need to actually project it. The question is framed, the non-delegation question is framed, others are as well, but the non-delegation question is framed by the vesting clauses. The first sentence of each of the 3 structural articles of the Constitution speak to the vesting of a particular kind of power or powers in a particular political institution, legislative powers and executive powers. Now, I think conceptually and structurally, and I want to emphasize, I'm operating right now in a completely formalist mode. One of the most puzzling challenges to Nick's and my work, one of the most puzzling challenges to Nick's work, well, you're my Nick too, to Nick Bagley's work and my work has been that it's functionalist and that it doesn't take seriously formalism. And I think that's it pays close attention to conversation and to actions taken, or at least we try to. But the formal frame for talking about non-delegation is central, I think, to our intuitions in the first instance about how this was likely to play out. And you can think the formal question involving 2 pieces. 1, can you delegate legislative power? And 2, can executive power can an exercise of executive power mean the creation of generally binding rules of general applicability? I want to focus only on the first one, and I want to keep it as fast as I can because I really want this to be sort of conceptually clarifying and then to dive into the real conversation that the wonderful commentary has prompted. I want to focus really on this first question because it's the question that Justice Gorsuch's challenge in Gundy focuses on. And you know, it's an intuitive challenge. Because if you think about the work that legislatures do, they make laws. I mean, this is like one of the first things that anybody will say to you if they haven't talked to you yet much about non-delegation doctrine, and you're saying that there's, you know, not one to speak of, is, well, what part of all legislative powers are vested in Congress did you miss? Which is not decisive for so many reasons. But what I want to emphasize is this notion that Gorsuch has, that the power to prescribe rules is vested in Congress alone, is at least in part a claim about, yes, delegation of legislative power, but also the nature of what it means to have executive power. So I want to turn to suggest through a specific example that's richly substantiated in conversations at the founding, to talk about how the executive legislative framework operated in such a way as to describe the act of making generally applicable rules as an exercise of executive power, which again, like I don't know, be the first to concede, I'll be the second to concede, is a little bit mind-bending, at least in the first instance. I like the Rousseau version of what is all over the sources in defining the nature of executive power conceptually now. Not what power should an executive have, but what is the executive power? Crucial distinction. Institution, what should the institution have, is not this question. This question is, when we whack up government power into legislative and executive, and sometimes judicial is a subset of the latter, what are those categories? So again, there's reasons to say that, you know, Rousseau shouldn't be your first sight. I just like it because it's a brief, nice sort of metaphorical explanation that captures what I've written at length is a really simple and almost embarrassingly simple structure of the separation of powers as it was understood in the 18th century. Every free action, he says, is produced by the concurrence of two causes. One moral, i.e. the will, which determines the act. The other physical, i.e. the power, which executes it. When I walk towards an object, it is necessary first that I should will to go there, right? Concurrence of two causes. I must will to go there, and then, in the second place, that my feet should carry me. That's the power that executes it, going back to the first paragraph. If a paralytic wills to run, someone who lacks the executive power, we'll see in a moment, there is no running that happens. If an active man wills not to run, there you lack the legislative prerequisite for the thing to happen. They will both stay where they are. And then, you know, Rousseau is not doing this like, you know, from modern perspective, like laughably naive account of human, like the mind-body relationship. We know that you actually often decide to do things before you actually think about deciding to do them. And there's all kinds of ways in which, in fact, this is a very naive view of neuropsychology, but he's using it as a way to talk about what the powers of government, as not as like, here I enter into a contested debate about what these terms mean, but like let's set our terms, and then I'm going to say all the argumentative stuff that I really want you guys to listen to. But I'm going to set my terms first. He says, the body politic has the same motive powers. Here too, force and will are distinguished. Will under the name of legislative power, and force, that's missing from this quote, my apologies, under the name of executive power, right? So the idea is the legislative power is the authoritatively intention or requirement formulating act of a sovereign entity. And the executive power is that portion of the sovereign entity's administrative apparatus that then turns this thing, which is an authoritative either prohibition or authorization, into like actual facts on the ground. That's a mouthful. It's very abstract. And what I want to do here, and I'm going on a little longer than I meant to, is to concretize it. I would, in the original paper, we used two examples that, as I said, are evidenced at great length in the records. I just want to focus on one of the two now, which is the act of treaty making. Like bottom line up front, or previewing the puzzle of some of the records here, the act of treaty making is sometimes described as legislative and is sometimes described as executive. And one way to think about that fact is that people disagree, maybe, with whether legislative is properly understood as executive or legislative. What I'm going to show and suggest is that it was properly understood in the conceptual grammar that they used as both, and that it depended on which perspective you took as to where the originating intention comes from. I hope that this quick visual will make things clear. The idea of navigation treaty. Diplomats sign a navigation treaty. The states who sign the navigation treaty via their diplomats have to permit navigation rights. This is understood from the state's perspective as the object of the instruction, making the treaty as an exercise of legislative power. The treaty imposes a new rule of conduct on them. And again, it's important to remember that legislative power can either prohibit or authorize, but it doesn't matter too much for this perspective. It is described as a legislative power repeatedly in the sense that the creation of a treaty creates new, officially enunciated rules of behavior. But treaty making was also said to be an exercise of executive power. How could that be if the sort of simple, thin account that I'm suggesting was uncontroversial at the founding was accurate? Well, think plenipotentiary. The way in which the treaty is created is by somebody being sent to negotiate and discuss the terms pursuant to instructions and authorizations. And I'm not talking only conceptually here. When they send plenipotentiaries to go negotiate things, they're not always plenipotentiaries, sometimes they're only partial potentaries. They have extensive instructions on those things which they can do, those things which they are authorized to give up, those things which they cannot cede on. They are acting as an agent, if you're talking in the British perspective, of the Crown. And so the Crown instructs the plenipotentiary to conclude a treaty. The plenipotentiary is authorized to conclude a treaty per those instructions. That means that from the Crown's perspective, what the plenipotentiary is doing in the act of making the treaty is an act of executive power. And they talk about it that way. Like, I'm not, this is both frames emerge for how they talk about it. Making the exercise, the treaty is an exercise of executive power. That's because diplomats are acting as agents of the Crown. And you see the exact same, I mean, in some ways, I'll put the final version of the next diagram up. You see the same thing when you see them talking about legislation. They talk about legislators both as wielding legislative power and also as wielding executive power. What the heck, right? Like, well, what's that all about? Well, what that is about is grounded in a democratic theory of representation and an emphasis on the fact that if you are a legislator, you're the delegate empowered to do certain things on behalf of your people. And this connects with the rich historical literature around instructions that are often issued in precise detail and are enormously controversial in England and Great Britain, but that the colonists insist they have the right to do because of this idea of the legislator as executive. So, like, kind of mind-bending. The work that this formalism is meant to do is meant to suggest that sort of the account that Posner and Vermeule, I think it's the two of them, maybe it's just Vermeule, offer about implementing instructions from the legislative, obviously being executive because you're executing the instructions. That's not an after-the-fact modern creation to be too clever about the vesting clauses. It is absolutely within the tradition of how the founding generation talked about things that government would do. And whether you were doing legislative or executive, at least sometimes, could depend on whether you were viewed as like the first cause, and you sort of drew a line behind you, you're the one making the decision, and you're saying go forth and do, or whether you're viewed in your act of saying go forth and do as the agent of some prior legitimately auzed popular sovereign sometimes, or it could be different kinds of sovereigns, who has told you to go out and legislate. That may have been a bigger bite to bite off in a brief period of time that I meant, but it's important. I just wanted to spend the initial time because I feel like this is one of the things that hasn't come through in at least some of the conversations that I've had. I want to emphasize that our account is both a formalist account that at least seeks, maybe not successfully, I don't know, I hope successfully, seeks to operate within the conceptual register of the founders, and also to demonstrate how that played out over time in practical political practice. That's the framing thing, and I will cede.
Thanks,
subside.
Julian. Ilan, you're up.
Great. Thanks for having me back on another panel, notwithstanding the fireworks on the panel yesterday. I promised some more fireworks today. I have three preliminary things that I want to say. First is I feel obligated to say that I'm also an SLS alum. I neglected to say that yesterday, but apparently it is a rite of passage to say that at this conference. The second thing I'm going to say is I'm really here commenting on Julian's paper that he posted for this conference. We already have published our views on this, and then Julian and his co-author Nick, I'm going to say co-author because we have another Nick, not the co-author, here with us today, and then respond to a lot of the critics, including me. So that's sort of what I'm here to do. And then the third thing I'll say is Julian and I spoke in the restroom before the panel, and we agreed that whatever happens, we will remain friends after this. So here goes. Okay. The short thrust of my comments on this paper is that every single objection or criticism that Julian and his co-author make about the originalist arguments for non-delegation, it seems to me, can be made about their own methodology, and even more so. And so I find the response quite perplexing. So let's start with the text, for example. Right off the bat, they say, well, you have to remember, there's no non-delegation clause. Therefore, this must be a structural inference, and kind of stacking the deck against the pro-non-delegationists. Well, there's no delegation clause in the Constitution either, which I think we have to be reminded of. The Constitution assigns and distributes power, and nowhere does it say Congress can delegate the power. So it seems that are assigned to it. So again, this I think applies to their methodology as well. Turning to the statements and contemporaneous debates, time and again, Julian and his co-author in this paper say, no contemporary said X about non-delegation, about how Congress needs to resolve important subjects, about how private rights are more important than public rights. The first thing I'll say on this is I don't think that's the originalist project. I don't think we're making specific claims about the founders' belief. I think, as Michael Paulson said earlier, we're trying to ascertain the most probable objective meaning of the text. Second, I think it's just not true on the merits. Julian and I have had this debate before many times, and I think, as my paper shows, something like 24 members of Congress and the judiciary made specific non-delegation arguments over the course of the first 20 to 30 years of the Republic. But the third thing I'll say, and more to the present point, I think this applies to their own method. No contemporary said anything like what Julian claims. No contemporary said anything even remotely approximating the proposition that there are no limits on what Congress can delegate. At best, they have Representative Bourne in the post-Rhodes debate, and I acknowledge that, though I do think it's a bit vague what he's saying. But okay, I'm not saying all the evidence is on one side. I've never claimed that. But the non-delegation side has 24 statements or so to counter that. And so I think Julian and Nick largely rely on historical practice and the actual delegations as illustrative of their claim. So let me turn to that. On historical practice, they also challenge the originalists. To be fair, the originalists argue on the absence of certain delegations. This is the overfitting problem that we talked about earlier. In response to that, Julian and Nick say, like the prisoners in Plato's cave, they write, originalists claim to know the doctrine not through direct observation, but from the shadows it casts on the statute books. Replace originalists in that sentence with Julian and his co-author, and I think we get an accurate description of their own work. After all, the bulk of their argument actually is historical practice from the British Constitution, the colonies, the Confederated States, and the early Congresses. Okay, finally, and I want to spend a bit more time on this, and Julian, this point will not be unfamiliar to him because we've talked about this before. In their paper, they characterize their opponents as engaging in remarkably candid special pleading by explaining away various delegations that were in fact enacted. Again, this is the overfitting problem. Well, let me suggest an example of special pleading in, I think, Julian and his co-author's work. I think it's an example that's representative of the broader method. So some background, and again, none of this is strange to Julian. We've talked about this example. Substantial amounts of their evidence come from British practice, but the problem is that the whole point of the British Constitution was that Parliament could do whatever it wanted. Parliament was supreme. As Blackstone said, Parliament could make and unmake the Constitution. It could exercise legislative power. It could modify and exercise for itself royal prerogatives. It could exercise executive power. It could exercise, and did, judicial power. And it could assign these various powers to the king, which it did, for example, in the notorious and detested Statute of Proclamations of 1539. Okay? But arguably, at least arguably, the case is different in America, where there's a written constitution that binds the legislature, okay, as well as the other branches of the government. So again, this isn't going to surprise Julian that I want to talk about a statement from James Wilson that he made in the Pennsylvania Ratification Convention. In that statement, he said that the Statute of Proclamations of 1539 could not strictly be understood to be an unconstitutional delegation of power under the British Constitution, but he said, in my interpretation of it, things are different in America, which has a written constitution that, in fact, binds the legislative power. Okay? Here's what Wilson said. Here's what Wilson said. The British Constitution is just what the British Parliament pleases. When Parliament transferred legislative authority to Henry VIII, the act of transferring it could not, in the strict acceptation of the term, be called unconstitutional. To control the power and conduct of the legislature by an overruling constitution was an improvement in the science and practice of government reserved to the American states. What is Wilson saying? He seems to be saying that delegations may have been okay under the British Constitution because Parliament could do whatever it wanted, but that's not the case under the American Constitution. Okay, so why do I focus on Wilson? Because in Julian's paper to this conference, he describes my use of Wilson as placing elaborate exegetical weight on this one sentence, which in his view speaks for itself about, I think, the weakness of the argument. But I think that's a rather unfair thing to say. I rely on this passage because Julian and Nick, in their original paper rely on this passage, and they cite it for the exact opposite of what it seems to say. They quote the first half about the Statute of Proclamations for the proposition that that delegations of power are not unconstitutional. And I merely point out that what actually Wilson seems to be saying is the opposite, that it might be unconstitutional under the British system, but it might well be unconstitutional under the American written system. So if I'm being exegetical here, I think it's in service of an exegesis of Julian and Nick's own method, because I think it's an example of what he calls special pleading. Right? The first half of the statement from Wilson could mildly be interpreted as pro-delegation, and so Julian and Nick take it as decisive evidence that Congress could delegate, despite the wildly different context. But the second part of the sentence, which seems to say the opposite, all of a sudden isn't about delegation anymore. Now they say it's about alienation, which they argue is a different concept. Okay, maybe. My point is only the two sentences go together. If it's about alienation, then the part about the Statute of Proclamations must also be about alienation. If it's about delegation, then the part about the American Constitutions must also be about delegation. And it seems to me that Julian and Nick want it both ways. They read any pro-delegation statement as pro-delegation, and then they encounter an anti-delegation statement. All of a sudden, it isn't about delegation, rather it's about something else. This is alienation, or it's idiosyncratic, or only one person made the argument, and so on. So it seems to me that that is an example of special pleading that occurs actually throughout their work in this regard. So let me just conclude by saying that it seems quite obvious to me that on the non-delegation question, there is evidence on both sides. My only disagreement, I guess, with Jillian, Professor Metzger, Jillian, not Julian.
Is fine. Julian is fine.
Jillian, but not Julian, is that overall, I think the evidence is that there is a non-delegation doctrine, though I admit in my work that the evidence as to its particular contours is certainly more disputed. But to say that there's no non-delegation doctrine at the founding and that the question isn't close, which is the proposition that they're advancing, doesn't seem to me even remotely plausible under the historical record. Thank you.
So Nick, as I said, I do believe you are the last panel speaker and a peacemaker.
Thank you very much. So as Jillian accurately stated, the position I've taken in my work is that in the evidence as of 1788, there may have been some abstract, unspecified constitutional limit on delegation. But the originalist sources, at least up to 1788, do not give us evidence of, as Ilan said, what the contours of it were, what the content of it was. And an implication of that is that it could be consistent with the non-delegation doctrine that we have today, which is a doctrine that does say there is a limit in principle, but it is a very wide, capacious limit. There seems to be only one historically existing congressional statute that actually clearly breached it, which is the provision of the National Industrial Recovery Act of 1933 that authorized the president to create these industry bodies that could impose these very open-ended output limiting regulations that could basically cartelize all the industries in the entire economy, which is struck down in the Schechter Poultry case. And so, you know, that may be the outer limit that is breached by the NIRA, but nothing short of that. In that reading, the Panama refining case, the second case to strike down statute under the non-delegation doctrine, would just be an anomaly. But what I've mainly focused on in my work, and what I'd like to elaborate on a bit more now, is what I argue. What I argue is, to borrow Katerina's term, a critical case. A critical case of delegation, which is the federal direct tax of 1798 that I already described to you in a bit of mind-numbing detail during the morning panel, apropos of its implications for statutory qualifications. I will now talk about it a little bit more in terms of its implications for non-delegation. So as I mentioned this morning, it is a tax that falls partly on land according to land's value, and you have this very large assessment apparatus that's set up, and then with respect to each state, there is a federal tax board that starts with the assessor's initial determinations of what each parcel of land is worth in money. Those are the statute's words, what each parcel is worth in money. And then the federal tax board can divide the state into federal tax districts and raise or lower the value of all the parcels in any district by any percentage, quote, as shall appear to be just and equitable. And neither of the key terms in the statute regarding valuation is defined. Neither the term worth in money, which is the standard by which the first instance assessment is to be done, nor the term just and equitable, which is the standard for the federal board's revisions, is defined. The legislation also requires no methods for making any of these determinations. As the Treasury Secretary Oliver Wolcott said in proposing the commissioner structure to Congress, he said that there is no necessity that the principles of valuation, his phrase, the principles of valuation shall be the same in all the states. In other words, the principles can be chosen by these administrative bodies. I also do not think it was the case that the federal boards were operating against some kind of background consensus for how to do valuation. As today, valuation of real estate was indeterminate and contestable. Alexander Hamilton in 1797 actually tried to convince the Adams administration not to impose a value-based tax on land because he wanted to avoid, quote, the very bad business of valuations. Because he thought valuations were maddeningly uncertain and contestable. And there's a bunch of other sources to this effect. You can look at my paper that was circulated in part 2 if you're interested in more sources. And then moreover, I mean, befitting the great subjectivity and sweep of these kinds of determinations, when analogous determinations about the relative taxable value of land across the regions of a state had been made for purposes of state taxes in the years leading up to 1798, all of the states that taxed land by value always vested the determination of the relative taxable value of land across the state in the state legislature. Okay, it was a decision made in the statute itself by the legislature. So I think that this legislation is a critical case, or it is a relatively direct counterexample for some formulations of the original non-delegation doctrine, but less so for others. It is most directly a counterexample for formulations of the non-delegation doctrine that say there was a categorical a categorical prohibition on administrative rulemaking, that is, administrative imposition of statutes like general generic directives that decide many individual outcomes uniformly at once. I'd say that the mass revision power of the federal boards was rulemaking in that sense. It was a uniform determination of a generic class of a large number of individual cases, the rights of many individual landholders. And then I would also say that the legislation is a critical case because of the exceptions that the proponents of this categorical formulation of the non-delegation doctrine have recognized to their formulation. From the get-go, Justice Thomas and Philip Hamburger and others propounding this view have said there is an exception to the categorical prohibition on rulemaking for legislation that is non-coercive, for legislation that is not domestic, and for legislation where the administrators are only authorized to find facts, to make factual determinations. So as to the first of those, I think you can see how the direct tax is a counterexample. It was certainly domestic. The object of taxation was land, and it was certainly coercive because it was a tax. But I want to say more about the third exception that Philip Hamburger, Justice Thomas, and others have always recognized, long before I did my study, which is that it's okay to have administrative rulemaking if the rulemaking turns entirely on a factual determination. Justice Thomas, also Justice Gorsuch, defined factual determination in contradistinction to policy determination. And so, and I think this deserves some very deliberate examination. How are we to understand the category of factual determinations as opposed to policy determinations? If the category of factual determinations is broad enough to include this power to do mass valuations with no definition of value provided and no methods for valuation required. And on that point, I want to say, I think the mere idea of land's value, instantiated in vague terms like worth in money, does not tell us anything until we choose a definition and a method. Determining land's value is not a determination about the natural world, like a determination about whether a substance leads to a certain disease. Nor is it a determination of a historical fact about something that occurred or didn't occur in the past. To be sure, there may be historical facts that are relevant to a determination of value, but which historical facts are relevant and how to get from those selected inputs to the outcome, the value, depends on what definition of value and what methods for deciding it we choose. For some kinds of property, like publicly tradable commodities, the method to choose is obvious. There's a public exchange that produces a transparent market price, and you can just rely on that. But land is illiquid and heterogeneous, so there is no obvious method. One possibility is to look at the land or the aggregate of the land and estimate its future productivity and crops, estimate the future market prices of the crops, and do a discounted future cash flow. Another possibility would be to get data on sales of comparable individual parcels in the past and extrapolate from them. Those are two possible methods, but what if the two methods diverge, as they would, for example, in a speculative bubble? And certainly there were speculative bubbles in the 18th century. Ask Robert Morris, the richest man in America, who ended up in debtor's prison because he got on the wrong side of a bubble. And then furthermore, even if you choose one method, the method is going to entail many subjective methodological choices. For example, if you extrapolate from past prices of comparable sales, You need to decide what sales are comparable temporally and geographically, but there might be very few sales that are actually nearby to or in the locality that you're trying to value. And also the land that has been sold recently generally is not a random or a representative sample of all the land in the locality. And actually reflecting on that particular problem, the economic historian Russell Menard, years ago in a study of 18th century land markets, said that in his view, it was impossible for contemporaries in the 18th century to come up with a meaningful average price per acre. So if administrators have the power to define value and choose the methods that determine it, I mean, the question I have is, what then is the differentiating principle between that and a whole panoply of broad delegations to administrators that we have in statutes today? What's the difference between that and OSHA deciding what substances pose a grave danger to employees, or EPA deciding what is requisite to protect the public health? I mean, I recognize that there might be some situations where all plausible methods converge in certain respects. For example, we might all agree that certain factual inputs are somehow supposed to be in the mix or are somehow relevant. Or we might agree on rough ordering of certain cases. You know, we can all agree that land in Boston was more valuable per acre on average than land on the frontier. But I mean, I guess my question is whether that distinguishes mass evaluation from these other kinds of agency determinations. In the case of grave danger in the Occupational Safety and Health Act, we could again agree on the relevance of certain kinds of data, but we might not agree on how to get from the data to a determination of what is and isn't dangerous. We could agree that logging is more dangerous than computer coding, but where to draw the line exactly between what's dangerous and what's not, again, is indeterminate. Now, if methods and definitions have not been specified, another possibility is that we could distinguish factual determinations from other kinds of determinations on the ground that factual determinations are to be done in a certain spirit. Okay, this is what Philip Hamburger argues in a response to me in his new manuscript, Non-Delegation Blues, which is on SSRN, page 90 to 91 of the manuscript. He says that factual determinations, quote, were expected to be done in a judicial rather than legislative spirit. He goes on to say that officers finding facts were to exercise, quote, discretion in the sense of discernment, discern, as opposed to exercise will. Now, I want to say a couple things. One is that I do think there's a tension between arguing that a task like mass evaluation is inherently judicial in spirit, on the one hand, and the historical practice by which all of the state legislatures that taxed land by value always vested the mass valuation determination in themselves, in the legislature. There's a tension between saying that something is inherently judicial and the historical practice by which it was always done by legislatures and never by courts. But even leaving that aside, if the spirit of discernment is the defining factor for what is a factual determination, and if it is defined this broadly to encompass things like mass valuation, where one is choosing the definition and the methods for what one is finding, then I think there's possibly an argument that agencies today are not so different. Agencies today typically couch their rulemaking decisions as instrumentally rational means toward a congressionally chosen end. The end is often vague and could support any one of many divergent ways of getting to the supposed end, and there is unavoidably a choice in getting from straightforward factual inputs like actual hard data to the determinations at the end of the process. But I'd say the same is true of deciding what is just an equitable, what is a just and equitable adjustment of what land is worth in money. At the very least, at the very least, I think this shows that it's a very fraught and indeterminate and contestable question how to draw the line between a factual determination and another kind of determination, a legislative or policy determination. And I think the difficulty of that line drawing introduces an element of indeterminacy into the categorical formulations of the non-delegation doctrine argued for by Justice Thomas, by Philip Hamburger, and others. And in that respect, I think that a criticism that they have had of Ilan Werman and of Gary Lawson and of other scholars who have argued for a more open-ended formulation of the original non-delegation doctrine is unwarranted. Hamburger, in his recent manuscript, criticizes Ilan Werman for the indeterminacy of the test that Ilan argues for, that Congress should decide important subjects and administrators should decide less important things. He says that's too indeterminate, but I think there is a significant element of indeterminacy in his own formulation and in the formulation set forth by Justice Thomas. I'm referring to the solo concurrence in the Amtrak case from 2015 particularly. I might also add that in the Supreme Court's jurisprudence on non-delegation, you see this difficulty of line drawing coming up in striking ways in Field v. Clark in 1892, the first case in which the Supreme Court elaborates the non-delegation doctrine at length. There's a question of whether a power delegated to the president to impose retaliatory tariffs if a foreign tariff is reciprocally unequal and unreasonable. That's the question. The majority says that's a factual determination. The dissent says no, it's not. Hence you see the room for contestation here that is actually baked into the history of the court's cases going back for some time.
Nick?
Yes, we can go on.
Okay,
yeah.
Thank you. That was actually very entertaining. So I want to urge people to come up to the mic if they've got questions, but also is there response from folks on the panel? If not, I have another question to lay at your feet. Yeah, okay. You want to go? Go.
A couple of quick thoughts. One of which is very much related to one of your questions, Jillian, which is about the burden of proof game. I love Rick Hills's description of baseline hell. It might not be his, but the problem of needing to define the baseline as being a prerequisite to talking meaningfully about what conclusions to draw from either silence or speech. In any event, the first I want to speak to two things. The first is a thing that I sometimes think that rhetorically I want to be more open about, and second, and other times I think that being more open about it is very hard to do without coming off as disdainful, which is that there's a version of originalism that gets you to non-delegation doctrine. It's a version of originalism that starts from extremely abstract principles and reasons from those principles to concrete, particularized conclusions about what the government is allowed to look like. I almost don't have a quarrel with that, except for the larger normative observation that that's a nutty way to run a railroad. But internal to the debates, and this is sort of what the part one of the current draft, which again, I cannot say how preliminary it was and that I circulated it only because the organizer said we need another paper, is to walk through almost, I try to keep myself off stage, I wrote that part. I try to keep myself off stage, but like the subjective experience of a person who went to law school in the 1990s and was really persuaded over time by a critique that emerges over and over again in dissents from Brennan and some Burger Court cases, and in majorities by the time you get to the Rehnquist Court, that there is a remarkable amount of willfulness and make-believe that is democratically troubling and, practically speaking, possible when you let judges do policy making from the bench, think about values, be Mr. Fix-It, right? This stuff landed to me as a young, like, Clinton liberal. Like, I come in, like, all fired up for, like, I'm gonna love all these cases. And I as I've gotten older, I think less of Scalia than I used to. But I actually, in law school, he was the person I wanted to clerk for most, if I was so lucky as to get a Supreme Court clerkship, because I just thought he was so, like, you know, fierce and things like on point and analytically, like, rigorous, and then demanding about the commitment to letting the Constitution be a document about democracy. And unless there's something in the Constitution that says you can't do that, then it's a political question. Darn it. Right? And there's lots of rights cases where, like, that's not such a sweet outcome for the kinds of values that I hold normatively. And so it has been bewildering to me, and I see non-delegation doctrine as, I didn't see it coming, that this paper was going to cause such a stir. I really didn't. I'm so stupid. It has been bewildering to me long before the non-delegation discussions to realize just how far the latest generations of originalists have, I don't want to say strayed, it's just a different way of doing things, but have gone from the original Scalian framework of democracy and leaving things to the political process being, in some ways, the fundamental legitimating thing about why we should do originalism, and not have crazy, wild-eyed Warren Court judges like just throwing rights around like they're candy. That's what I see happening here. I see the Glucksberg case as an example of an effort to say, look, sometimes we'll allow rights development to occur. But Glucksberg is not an originalist case, but it's a historical case. So sometimes we will allow rights development to occur. And we'll even maybe reason upwards a little bit from the very particularized instances that we're at first focused on. But boy, before you tell a state government or the federal government, you can't do that. I want a long, rich, flourishing, florid, undeniable, embraced, actively engaged with tradition of this thing being a thing that the American tradition protects, right? That's like the what? Like part of my reaction to the last 2 years of conversations about this, because I mean the parallel should be clear. That's what's happening here, and so that pivots me to the second thing I want to say, which is less as a definitely not an originalist, and less as an observer, sort of the, I don't know, historiography, the intellectual history of originalism, to speak as a historian. And I have become increasingly bold about saying, yes, I'm a historian, notwithstanding the lack of a PhD. As historians tell me, you should call yourself a historian, given what you've done. So speaking as a historian who spent massive amounts of time in primary materials and in secondary sources that walk you through the different frames for understanding the past, there's no way to convey in writing this sort of baseline problem, the denominator problem. This is what, like, Nick and I have talked about, like pie charts maybe would do it. There is so much material from this period. So much. And they are arguing about everything all the time. And they're so creative. And like, this is one of the great joys of the period, is, geez, these guys are super creative and super interesting and innovative, and they say a lot of crazy things a lot of the time and stupid constitutional arguments. And if you go through the record, you see all these things. At least my experience is going through the record, I've really focused on the 1770s and 1780s. You see all these things that absolutely prefigure modern debates. They talk a lot about enumeration and what enumeration would mean, both in the Continental Congress and certainly during the ratification debates. They talk about free speech, search and seizure. There's lengthy debates about how to interpret purposivism versus textualism. Sovereign immunity is a thing that comes up in conversations about how to understand constitutional documents. Like, all these things that we think of today as being doctrines, in the sense of having some relatively understood core, at least. And as like, people disagree over doctrines. It's the first thing in law school. It's like, in crim, it's like, well, there's the majority position and the minority position. Like, this is the classic tort thing. It's like, well, I have to learn every possible view that you could have on this issue, because the teacher might say this is a mailbox jurisdiction or something like that. They are arguing, as I said, throughout all of this material about all these things that are recognizable to us as pressing concerns about which there's maybe some disagreement, but about which there's also agreement that it's a thing. There really is not, I mean, I'm going to say none, asterisk, 17 pieces of paper or something like that. I have a slide that I sometimes use to show this. I would be shocking. I went into the project expecting to find contestation, right? The blithe, confident statements there was that the executive power effectively equates to the prerogative, and seeing the historical record, from my perspective, completely belie that, was the same sort of experience. I thought there'd at least be contestation. I came to the non-delegation stuff basically thinking, geez, I've been reading a lot of statutes because of the way that executive power often interoperates with statutes, and I expect there'll be some debate about this. Reading generously as you can, and conceding every inference, some of which I think are too aggressive and mistaken, to like say this piece of evidence must be a demonstration that person X believed in none. It's 17 pieces of paper. It's less than that before 1789. And so I went on too long, and I apologize.
Thank you, Julian. I'm going to let Ilan, he has promised me it will be little comment, and then we're going to go to Jed.
No, I guess my only initial reaction to Julian is they do emphasize a lot this silence in the record. And I'll just say two things about that. One is you have to be careful, and Julian knows about this, right, not to fall into the fallacy of negative proof, right? Just because people didn't say things doesn't mean there wasn't about some proposition, doesn't mean the proposition wasn't true. It only works, the absence of statements only works if there would have been reason for them to say those statements at the time, and they didn't make those statements. Now, when there were occasions, they did, right? They did on 17 occasions or wherever it was, and Julian has good responses to them. Well, it didn't win the day, or it wasn't a convincing argument. But the point is, when there was incentive to make the argument, they did. They did. In most of the debates, there was no serious question that there was a delegation issue, right? Because Congress passes statutes. Every statute delegates authority to the executive. That's not the same thing as delegating such authority that it amounts to the legislative power. And so that's the first thing I'll say. The second, again, as a small point, is no one controverted the principle when they did argue. Even in the post-Rhodes debate, Sedgwick, the one who wanted to delegate the power to designate the post-Rhodes, didn't say, no, Madison, you're wrong, there's no non-delegation principle. He said, look, we establish the principles, the executive administers the details, that's the line, and we've met it here. Even they didn't controvert the principle. My reading of Julian and Nick's paper is they controvert the principle. And there is no evidence of anyone taking that position other than a half sentence in the post-Rhodes debate of all the historical record that I've seen.
Jed.
Great. First of all, thanks to all five of you. And I know this debate has been going for a while, and I think we all appreciate your willingness to continue this debate. And
it's your fault for bringing us all together to do it.
Absolutely, and I hate to break it to you. I think the debate's going to keep going. It's just, and I would hope you would keep.
Not with me in it. This is my last one.
Yes, I understand. But thank you for this part of it. I think that two questions. One is, I think, going back to Jillian. I think you've all touched on it, but I want to go back to Jillian's opening question, which is about the burden of proof. And I can't speak for historians, but I can say that as someone who studies and writes in history, sometimes you have a burden of proof on a negative. I mean, so there are claims that X did not happen or there was no X, which is different from a claim that critiques someone else for making a claim. So I don't think it's just the positive or negative that creates the burden of proof. There are lots of examples of, in terms of territorial claims. Group people X did not live here. Well, that's a claim, and you have a burden to show that happened. And in my own work in this area, like some claims I make is that the word vesting did not connote indefeasibility. I need to defend that. But I also make a negative claim, which is that vested rights doctrine about property rights was a phenomenon post-1800, and that was not. So I make a negative claim, and I have to bear the burden on both. But I think I think the irony, or maybe it's a coincidence here, is that there's a separation of powers argument here. That who's invoking the power? Maybe this is kind of a Robert Cover idea of law being jurispathic, in that when you exercise power, you need to explain why you're creating and destroying. And when the legislature delegates, I think there's a historical question about whether a legislator has evidence historically that they can delegate. And a legislator needs to persuade themselves that they have that power. But I think what we're really talking about today is judicial power. Right? The non-delegation doctrine that's relevant right now is the Roberts Court Gorsuch claiming that there is a non-delegation doctrine. So I think if your audience is to the Roberts Court, I think the burden of proof is on Elon. I think you've got the burden of proof to say to the Roberts Court, if you're going to file an amicus brief, I think that amicus brief needs to acknowledge that for your audience, you have the burden of proof to establish that there is a non-delegation doctrine. So it's one way of framing it. The second question, I think, goes back to the first Congress, which is, there is an evidentiary problem, and this is more of a challenge to Julian and Nick, and a challenge to my own work, which is that the first Congress is not obvious that that is evidence of constitutional meaning, because the nature of a constitution is to prevent the next actors, not in 50 years, but in the next month, from doing stuff. And Article 5 tells us that. Article 5 says, regardless of what, whoever's elected, you can't stop the slave trade until 1808, and states can't lose their representation in the Senate, because they were worried about the next political actors making that change. So we also know this from Marbury. Like, Marbury strikes down, the Judiciary Act of 1789 is unconstitutional regardless of what the first Congress thought. We think of the Alien and Sedition Act as unconstitutional. Probably all the states that stripped judges out of office and created new courts, like they did in Maryland in 1802, that was probably unconstitutional. So I guess the concern is the 1790s could actually be the problem and not the sources.
Elon, Julian, Nick,
Just well-taken comments from my perspective.
The one brief observation I would say is that that's why the baseline is so important. If what you're interested in seeing is what was reasonable to argue, or not reasonable to argue in the sense of people violating norms that were imposed on them, the story before 1789 is delegations in every direction by every political actor over massive discretionary decision-making, including in state constitutions that had vesting clauses, including in state constitutions that had separation of powers clauses. I mean, there's not a lot of detail on the latter. We're still building the evidence on that. But that's one of the reasons why I think it's incredible. It strikes me as mistaken to draw the line at 1789 and say everything changed because of my contestable reading of what these words in the text mean, where nobody said it.
Can I want to get you, Jack. I just want to follow up on, because it relates exactly to that point. Because one of the questions I had is there evidence from you who have all studied the historical record going beyond this period then of particular understanding developing or not? And what is the timing of it that you see?
I mean, the big paper on this that I'm aware of is the Giuliano and Whittington paper that goes through the episodic emergence of non-delegation arguments, especially in state courts in the 19th century. Interesting thing about state courts, actually, and this really emerged in a way that I think surprised some people who are trained on federal practice. Some state constitutions, as they've been interpreted by their courts, have quite vigorous non-delegation doctrines and have for like a century, right? So it is far from, it makes, like, my normative preference is to have less delegation, or at least more narrow delegation. It's not hard to work from a separation of powers instinct to the conclusion that there's got to be some limit. I'm sure that I buy that line of argument. And you do, in fact, see lots of state courts that have, I think in part for that kind of obvious logical dynamic, adopt non-delegation doctrines that are real.
Jack.
So I have a kind of, more of a comment and less of a question, but, one, I think, directed particularly to Nick, and the other, I think, would be of more general interest. So, Nick, just towards the end of your remarks got me thinking of, there's a paragraph in Federalist 10, which I spent a lot of time with, and I'm working on it right now because I have to finish a paper on separation of powers for a conference on Montesquieu and the founders, in Paris next month. So Madison ends his famous paragraph on faction by saying, the regulation of these conflicting interests forms the principal task of modern legislation and necessarily makes the spirit of party and faction part of the ordinary operations of government. But he then goes on to say, to raise this really interesting observation, which I think really complicates any attempt to think substantively about what the whole conception of separated powers means. He says, what are most legislative acts but judicial determinations? Not indeed concerning the rights of individuals, but concerning the rights of whole parties. And then he goes on to give three examples, all of an economic nature. So one has to do with debtor-creditor, the second has to do with protective tariffs and consumers, the third has to do with any scheme of taxation. What makes these judicial determinations? Because all affect rights of property. And since property, one could happily be Lockean and say property is central to any Anglo-American conception of how we think about rights. In fact, rights are something we own. Both Locke and Madison agree that we should think of our rights as part of our property in some literal substance sense of the term. So, you know, I've had a kind of little dispute with Gordon Wood about this because Gordon has written that, in fact, Madison wanted judges to be more like, wanted legislators to be more like judges. And I think Gordon's wrong. I think what Gordon is saying is the nature of the enterprise of lawmaking, particularly in the economic realm, which of course includes taxation, your concern in 1798, is necessarily judicial in nature because of its impact on the rights of property. So I think kind of, I mean, you know, if you want to, take a step back and think conceptually about the intellectual universe or whatever these guys are inhabiting, it seems that Madison's insight, A, is like most of his insights, quite powerful, and B, whether or not he's Hamilton, whoever Mike is, he did have some role in this whole process. Unlike Hamilton, he actually was a framer of the Constitution. I mean, Hamilton just shows up periodically and says something, and then disappears. Okay, so that's point number one. Point number two, I do have a comment about the vesting clause. And this is a bit of a personal story, but years ago, Neil Katyal asked me to write a brief in Hamdan versus Rumsfeld. And on the other side was Forrest McDonald, a legendary character for reasons I won't get into in the historical profession. I don't think I saw Forrest's brief, but I knew Forrest had written somewhere. I know in my brief I answered a point I rightly anticipated Forrest would make. And Forrest made a big deal about the vesting clause, that working behind anti-federalist fears of the presidency was the potential of the vesting clause as the kind of network of authority that most people sitting in this conference have come to reckon with it. The problem with that argument, at least I wanted to have a footnote, at least a footnote in my brief contesting it, is the one thing we know about the anti-federalists is that they were never cautious about voicing their objections to the Constitution. Any fear that they had, and they had a whole bunch of them, and every commentator who's written about the debate, including my mentor and Eric's colleague, we tend to call him Bud, not Bernard Balin, Bud Balin, but everybody else, William Riker and Cecilia Kenyon, and myself and Gordon and so on. The one thing we've emphasized in the Anti-Federalists is if there was something to fear, they weren't shy, or restrained about fearing it. If they thought the vesting clause per se, ex vi termini or whatever, was its own source of danger, they would have said so. So I wanted to make that, because I guess I'd learned a bit about how things, I'm married into a family of lawyers, and these guys know I hang out with them all the time. But I still don't fully think like one. I need to learn correctly. So jurisdiction's really important, when you are, that's news to me, and so on. But but it seems to me, this way of, given, because we are trying to reconstruct a debate here, which is actually what historians do. We don't pronounce doctrines. I think primarily we try to reconstruct debates and figure out which side seems more persuasive, which than others. But I think that is, in terms of this larger conception, I think that's also a point that's well worth considering. I mean, I think Forrest was wrong. They'd really feared it because it was so potent, and it as soon as you'd see it, they would have said something about it. So that's an occasion where silence, I think, actually indicates a lack of attention, or in fact, a kind of indifference or disinterest in this. So I haven't asked everybody a question, but at least I probably given you guys a couple of things to think about.
Thank you, Jay. John.
So let me start by thanking all 5 panelists for a really impressive discussion. You all laid out issues so clearly, and I feel like I've learned a lot from this session. I wanted to ask each of the 3 principal authors a kind of devil's advocate question or skeptical question. And these are just things that occur to me as potential vulnerabilities, or at least something that you ought to maybe address. So for Ilan, you talked about the fact that just as there's no non-delegation clause in the Constitution, there's no delegation clause either. And one response to that would be, well, there's the necessary and proper clause. The necessary and proper clause vests Congress with the power to make all laws, which are necessary and proper to carry into effect all the powers of government. Now, so you might say, well, necessary and proper. I've got a particular meaning of what improper is, but I'd like to hear that story, because those of us who've researched that question, I think, are going to be skeptical that you would find some kind of technical, intended, or understood meaning in the phrase necessary and proper that would encompass what it is you need it to encompass. So I'd like to hear you address that question, and sort of an observation of this whole debate is I often feel like the necessary and proper clause is a bit missing in the debate. And so for Julian, I imagine you guys have addressed this in your work, but I just can't recall if you did and what you said. But I don't want to get into the debate on Wilson that the two of you were having, but I am mindful of Hayburn's case. If someone said, did James Wilson believe in a non-delegation doctrine, I probably would want to take a close look at Hayburn's case and understand, well, how would one interpret that? It certainly seems to be a case in which not just Wilson, of course, but all the justices say, Congress, you just did something improper. You purportedly delegated to us an authority to do something under this statute that violates a structural provision of the Constitution. Now, I can see that's maybe quite a bit removed from the kinds of debates that Gorsuch is talking about and Gundy and so forth. But I'd like to hear, just again as a kind of a devil's advocate question, what your response to that is. And then Nick, frankly, it's hard to come up with a good question for you, but the work you've done on this is so thorough and so impressive, but as is the case for all of the authors. I am wondering whether your remarks about what the commissioners are tasked to do here and the kinds of valuations that they're doing, I wonder whether to us that sounds so obviously like a policymaking function because we think in 21st century terms. If I had to play devil's advocate, I would say something like, well, let's remember, for example, there used to be in the law of contracts a substantive unconscionability doctrine, which in the 18th century I think rested on notions of an objective price of goods and services that was discoverable, just like pretty much everything the judges were doing was purportedly a matter of discovery, not a matter of making the law in a modern policy-making sense. You are talking about valuation and price. And I think to myself, if I had to argue against you, what would I reach for? It might be something like that, where I think in the law of the law of contracts in the 18th century, or maybe other bodies of law, we might have a kind of a different metaphysics and ontology and jurisprudential set of commitments about what we think judges and lawyers and commissioners are doing when they, for example, price land. So that's just a kind of a skeptical question.
So let me start with actually what Jack said earlier. Again, when the Anti-Federalists had said something, I actually think, and I wanted to mention this earlier, but Julian provides an explanation in his paper. In his paper, he says, at ratification, the founders saw no reason to assume that Congress would be unwilling or unable to protect its prerogatives. Legislative abuse, not legislative abdication, was top of mind. Yes, exactly. No one was worried that Congress was just going to give away its legislative power. Everyone was worried that Congress was going to try to take the president's power away or act like a court. This explains why there's such an absence of statements. On the necessary and proper clause, I'm going to tell you a story which I know some people don't agree with, but at the moment, not having studied all the sources, not having read Fisher recently, which I know you've talked about, my understanding, and certainly I think Chief Justice Roberts' understanding, is that the necessary and proper clause is a grant only of implied powers. What does that mean? It cannot be a grant of great substantive and independent prerogatives. The classic example that Mike McConnell and Mike Paulson use in their casebook is if I give you an authorization, I say you can go to my office and borrow X book from my bookshelf. Is that an implied authorization to move stuff around to look for the book? Yes, it is. If you show up and my office door is locked, is that an implied authorization to break down my door? No, it's not, because some things are too great and important to be left to implication, like war, taxation, things that are in fact enumerated. And here I think we go back to Jed and fiduciary constitutionalism. I think whichever you look at, the power of an agent to subdelegate authority, it was understood that it cannot be left to implication, because that's too important. Because if you delegate to an agent, you've put that trust in that agent, and subdelegation has to be expressly authorized. Any part of that story may be false, but that's the story I would tell. And the last thing I just want to say, doubly on the record, is that Nick defended me against criticism from Phil Hamburger, and I just wanted to relish that for a moment and reiterate that for the record, for those who missed it.
Go ahead.
Hayburn's case is, where did John go? Oh, sorry, I keep doing this. Hayburn's case is not something that I've thought carefully about, how it might bear on this question. The first thing that leaps to mind is there is resistance, not in the sense of calibrating when it's okay and when it's not, but in the sense of folks saying X type of handing off of government power is absolutely prohibited when it comes to certain kinds of actors, right? So there actually is evidence for people arguing that you can't delegate governance power to private delegations. And like, there's a reason for that. And there's case law going back to the Stuarts about that. And there's really bitter and difficult experience with the trading companies who have sovereign powers effectively in the areas that they're in charge of. And so my first instinct, not having read or realized whether there's any hook for this at all, is to think about whether the target, the recipient of the delegation, might be doing something there. But the truth is, it's a great suggestion, and I will maybe not this afternoon, but probably tomorrow, reread Hayburn's case and try to think about it. Thank you.
John, it's a really interesting question. I mean, I've tried to research contemporary ideas about real estate value, I mean, but of course, you know, and I think what I've found is a recognition of contestability and uncertainty. But I mean, if one were to research further and find, you know, a subjective contemporary belief in factual determinacy of these things, what then would that mean? And I'd say if one were to find that, one would then also need to reconstruct contemporaneous beliefs about factual determinacy across a whole range of things, which might include lots of things that we think of as obviously policy. And under, you know, certain formulations that are on offer, such contemporaneous evidence would render those things delegable as well, too, I take it, because they would then be in the fact bin. So, I mean, that's a possible, you know, implication if hypothetically one were to be convinced of the premise that you articulate.
Nick, what was inflation like in the 1790s?
Well, so I mean, the money supply. I mean, the money supply is a big deal and a big problem in the late 18th century, and it profoundly affects land prices. And I mean, you know, because of the contraction of the money supply in the 1780s, land prices fell like 25 to 50% in the 1780s. They start to rise again in the 1790s. In 1797 to 98, there is a recession and there's increased complaints of money scarcity, which would then raise questions about, you know, how valid are all these recent sales if they were under different market conditions than now. So I mean, that is, that is an issue. Yeah.
Since time is just about out, I think I'll be real fast. And I was surprised that we didn't hear anything about delegations of adjudicatory authority. You know, we have regulations, we have adjudications, and it just seems to me that adjudication is a much more problematic matter. For one thing, it can't be delegation because Congress doesn't have the adjudicatory power to begin with. So, so why is it that, or is there maybe a separate doctrine, or do you have any sense of what the original sources say about such things as administrative agencies imposing fines on people?
Are you channeling the Fifth Circuit?
So I think that I think that, you know, Philip Hamburger's book has really set the terms of this debate and has opened up so many of these questions. And I mean, he has critiques of both administrative adjudication and administrative rulemaking. And then Justice Thomas in the Amtrak case in 2015 picked up on the critique of rulemaking and, you know, argued for a reformulation of the non-delegation doctrine on that basis. And I think that helped to frame the debate about non-delegation as one that's very much focused on rulemaking. But I mean, I remember a conversation with Gary Lawson in which, he said he thought the debate should be more, more capacious and take more account of adjudication. Of course, if you look to adjudication, then you have the Article 3 jurisprudence and the public rights doctrine. And I should mention that Ann Woolhandler at the University of Virginia on SSRN has a very interesting short response to my article in which she argues that, that the Article 3 jurisprudence on public rights could be understood as also applicable to Article 1, which would render taxation an exception to the non-delegation doctrine as to rulemaking, just as it is for adjudication as to non-court administrative adjudication. Regrettably, we didn't have time to get into that.
I'll also be brief. I know we're running out of time, but I wanted to kind of maybe bring some of the insight from the previous panel to bear on the non-delegation story, because, and Elon was just getting at this in one of his responses, like the reason you may not need a whole lot of actual evidence in the specific record, Julian in particular, that you and Nick are looking at, is because it just was so well understood that certain kinds of fiduciary officers just couldn't do certain kinds of delegation. Now, exactly what the contours of that were supposed to be. So, Elon, I think you just showed, like what I was in our panel a moment ago, what I was trying to highlight is this incorporationist tendency of fiduciary constitutionalists to say, well, they were all agents, and agents can't subdelegate in just that way. We're not, I mean, you just can't be that confident. I mean, it's certainly what Lawson and Seidman say, but, they don't have a lot of evidence for it, and it's the agency law, the extant agency law at that moment is not actually quite as clear as they make it. And this paper that Jed and I wrote, trying to urge a different kind of analogy, not the agency analogy, but a trust analogy, the non-delegation doctrine in trust law was actually much more flexible. And has always been. I mean, it's nominally they have a non-delegation doctrine, but in practice it was always very, very flexible, and in fact reinforces the kind of flexible non-delegation doctrine we actually have. So, I was a little frustrated, Julian, that you're not engaging the fiduciary constitutionalists because, and yet Elon, you take it too seriously. So anyway, I just encourage you guys to take me and Jed more seriously. Yeah.
Awesome. Michael, we're going to turn it over to you.
So. I'm not going to speak long. This is the end. Thank you first to this panel. They deserve a warm thanks for an interesting discussion. And thanks to all of you, both the speakers and the attendees, for a very stimulating conference. I know that when I plan to, to sort of think this through and to digest it in my own mind, my method is going to be something like this. I'm going to take each of the panels together because I think the cross-fertilization in some of them, such as what Ethan was just speaking about with the last panel here, but some of the cross-cutting issues, such things as is there a difference, say, between the executive power and the strictly executive power might be a way to frame the delegation question. Is there a difference between legislative power and strictly legislative power, which can't be delegated? And I think the removal issue that we were talking about, is that an executive power? Is that a strictly executive power or not an executive power at all? I think we've been given a rich feast of things to think about now, and I don't know about anyone else, but I'm anxious to get out into the beautiful sun for the rest of the day. So please accept my thanks for being here, and farewell.